Okay. I'm gonna go ahead and take attendance, and then we'll go ahead and dive into talking about various types of trials. And sort of what happens during a trial. Everyone who's here in person first. No, that's all 5 of you. Okay. Okay. There we go. Alrighty, so we left off, we had just talked about the various possible purposes of a trial. So next what we're going to talk about is what actually happens during a trial. So again, just a quick reminder, since we did this last, what is the purpose of a trial? You know, is it a search for the truth? It's sort of idealized, right? It can be difficult to meet this ideal because of the fact that, you know, stuff gets sort of obfuscated. The trial is a test of credibility, which again, not always great, but what ends up kind of coming out of this is that the trial is a conflict resolving ritual. It provides a mechanism to resolve controversies and to create the sense of justice that's being done. So these are the steps in the trial process. And so trials themselves, depending on the nature of the case, sometimes trials are very short, and sometimes trials can be weeks or even months long. So the preliminary actions we've mentioned already, including discovery. Discovery is the pre-trial process by which each side tries to gain information, vital information. So things like police records, interviewing witnesses, and trying to get the information about the case that will be presented by the other side in particular, because they want to be able to prepare, basically, essentially, who is doing what and how can I kind of counter that. And then they will draw a panel of prospective jurors called a veneer from a large list. So if anyone's ever had jury duty, we're going to talk about a lot more about this starting Thursday. But they go through something like the voter registry or lists of licensed drivers, and they randomly select a big pool from that. Those are the people who get notifications to come for a certain day, or I believe in this area it's a week for jury duty. And then you kind of sit around to see if you're actually called to be on a jury. But even if you're selected in theory to be on a jury, you're going to be in this panel of prospective jurors where you can get sort of no thank you rejected for various reasons. And then there's a process of, again, on Thursday, we're going to talk about it in a lot more detail, called voir dire. And this is used to question the jurors and select the eventual jurors. So they do things like rule out people who seem biased. So for example, my mom once got sort of dismissed from jury duty because they asked her, it was a mugging case, and they said, could you be objective? And she said, well, no, I got mugged myself last month, so that's very fresh in my mind. And so they just said, thank you for your time, and she was done. So there's a whole host of reasons why jurors may be eliminated. So then once they have the jury all selected, then you have the trial itself. And the first thing you see are opening statements. So lawyers for each side are permitted to make opening statements. These are not part of the evidence. They're just overviews of the evidence that will be presented. And again, it depends on the case, how long these are. So if there are large cases, sometimes each side's opening statements take like a day or half a day, right? Whereas it may be in like sort of a less high profile case, it might be much shorter. The prosecution or plaintiff typically goes first, and then the defense's opening statement follows immediately after. Or the defense can choose to wait until it's their turn to present evidence. So, there are different reasons why you would use different strategies, but typically it's going to be right after the prosecution's opening statements. Once the opening statements are done, the prosecution or plaintiff will call its witnesses. Each witness testifies under oath with the threat of a charge of perjury if the witness fails to be truthful. Perjury is taken very seriously. You have lied while under oath. The oath is you're saying, I swear that I'm going to tell the truth, the whole truth, and nothing but the truth. And, because we're a really interesting country with how we treat religion, it's often accorded with so help me God. Perjury, just to give you all an example. So this is before I think all of you were born, but I was alive in the 90s. And President Bill Clinton got impeached. And everyone sort of like the narrative is it's because he had an affair, which is great. And actually, he was technically sexually harassing his intern. But in fact, why he got impeached is because he lied under oath. So they asked him, have you ever had sexual relations with Monica Lewinsky? And he said no. And there was plenty of evidence to the contrary. So it was the act of lying under oath that actually got him in a lot of trouble. And so perjury is taken very, very seriously. Each witness undergoes direct examination. So that is the lawyer that is bringing you as a witness for their side is going to question you first, sort of guide you through to lay out your story that supports their side. Then they'll be cross-examined, undergo cross-examination by the opposing attorney, where they try to poke holes in the witness's story and show that the witness isn't credible, for example. And then there can be redirect, where the prosecutor gets up again and questions that person again, trying to undermine what the defense just did, right? And then they can recross. So each witness in theory can go through 4 rounds of questioning. Now they don't always do that. Sometimes for the redirect or recross, they'll just say like no further questions, Your Honor. But in theory, especially if you're a key witness, you can be on the stand for quite some time. After the prosecution's or plaintiff's attorneys have presented all of their witnesses, then it's the defense's turn to present their witnesses. And not surprisingly, each witness is going to undergo direct examination, cross-examination, redirect, and recross. And again, same type of scenario. Not necessarily everybody will be drilled on everything. But they have to be sort of mentally prepared. And if you have a good attorney and you're a witness, they will prep you. So they will, give you the idea of the type of questions that will be asked. They may even have you practice. They'll give you recommendations about not like yelling at people, things like that, right? And they give you tips like, I don't know and I can't recall are perfectly good answers. And you don't, some people use that to just avoid answering anything. But again, if we're trying not to perjure ourselves, there are things that genuinely you probably won't recall. So again, this is just fresh in my mind because it just finished the Gwyneth Paltrow ski accident trial. There was a whole time where they were trying to like get her on like details of it. And like, well, you were talking to your son and blah, blah, blah. And she was like, I don't recall like exactly what we were talking about or where he was on the hill. Like she was super honest about it. Right. And that is better than making stuff up, right? Because again, you're perjuring yourself in theory. After both sides have presented their witnesses, one or both sides may ask the judge for permission to present rebuttal evidence, which attempts to counteract or disprove evidence given by an earlier witness. So this may end up being an expert witness, right? So let's say an expert witness testifies about the nature of psychopathy, right? And you've got a different expert witness who has a different theory. You might bring them on to do that. Once all the evidence has been presented, each side is then permitted to make closing arguments. And closing arguments are summations. They are wrap-ups, is sort of the lawyer's last-ditch attempt to sway the jury to their side. Typically, the prosecution or plaintiff gets the first summation or closing argument, followed by the defense, and after which the prosecution or plaintiff responds to the defense. And then the final step before you go into deliberation in a jury trial is that the jury will be given instructions by the judge. Although in some states, the instructions will precede closing arguments. So the judge informs the jury of the relevant law. This is the law that you're looking at, right? You might think this is a horrible person in general, but what we're looking at here in particular is murder one, right? Or, petty theft or whatever it is, right? The judge will explain that. The judge will also instruct jurors about the standard that they have to use in order to weigh the evidence. So with criminal charges, jurors must be convinced beyond a reasonable doubt that the defendant is guilty before they vote to convict. Now, there's no like percentage for that necessarily, but it is a pretty high standard. Essentially, you're saying we're convinced that this person is guilty. There's no sort of doubt in our minds. In a civil trial, what you're typically using is what's called the preponderance of evidence. And that's all that's necessary for finding in favor of one side. And so I've heard preponderance of evidence described in several ways. 51% of the evidence seems to point to that side. I've also heard 50% plus a feather, right? And so it's just like a tipping point of evidence in that direction. And then what happens is the jury goes and deliberates. And depending again on the case, this can be very short or a very lengthy process. So some juries may only be out for under an hour. Everything was pretty convincing, they come back in. Some juries may deliberate for days, just because they want to go over all of the evidence, and the juries can ask to like re-see evidence or things along those lines. When the jury reaches their verdict, then the foreperson informs the bailiff, who is the sort of security person in the court. The bailiff will inform the judge. The judge then reconvenes everyone. You get the attorneys back, you get the defendants and plaintiffs back, and everyone's back in court for the announcement of the verdict. And typically the jury foreperson, there's a couple ways I've seen it. Sometimes it's delivered to the judge and the judge reads it, but other times the jury foreperson actually says, what their decision is. This person is guilty on this count, etc. And so there are obviously pros and cons of the way that we do trials, and it's very different in other systems, as we talked about at the beginning of the semester. So advantages for the prosecution. I mean, first off, they get to address the judge or jury first. There's something in psychology called the primacy effect, which is you really remember the first thing you hear. And so this is an advantage. This is going to stick with you. And also, oftentimes, the first thing you hear, you then judge anything else you hear based on that, right? So you hear that this person is guilty, and then you're kind of skeptical of the other evidence, perhaps. The prosecution also has the full resources of the government. All right, so these are the prosecuting attorneys. These are folks who are sometimes they're elected, sometimes they are nominated. So they have those resources. The prosecution also gets to present its evidence first, again, that primacy effect. And at the end of the trial, the prosecution gets to go first and also has the chance to offer a final rebuttal. The big advantage to the defense is that they have no burden of proof. You are innocent until proven guilty, right? So it's the prosecutor's job to prove you are guilty. The defense doesn't have to prove you are innocent. The prosecution during discovery must turn over what's called exculpatory evidence, so evidence that is actually going to have an impact on the case. The defense may have more opportunities than the prosecution to remove potential jurors during voir dire. Again, this varies jurisdiction to jurisdiction, but in some cases, the defense gets essentially more vetoes for jurors. Defendants do not have to take the stand as witnesses on their own behalf. I think that's a common misconception where people are like, yeah, the defense has to get up there and talk about what happened. They don't. They're not legally required to. And the lawyer can decide whether or not that actually would be in favor of their case. Again, you have someone who's a psychopath, you probably don't want to put them on the stand unless they're really good at coming off warm and caring, right? And putting up that facade. Or you just have someone who, understands the basic concepts enough to participate in their own defense. So they're not incompetent to stand trial, but maybe they're just not that bright and can't describe things that well, right? Defendants who are found not guilty can never be tried again for that specific crime, and that's called double jeopardy. There's, I think it's from the 90s. There's an Ashley Judd movie based on this premise where she was falsely accused of her husband's murder, and then it turns out he was alive. And so then she's like, I could just kill him because double jeopardy. And I'm like, I don't know if that's how it works. Would not recommend. We'll put it that way. Also, fun fact about that. I watched that movie in my dorm room my first year of college, and we realized the bunk beds they were using in the prison scenes were identical to the bunk beds we had in our dorms. Woohoo! Alrighty. Okay, so you've been through the whole trial, the jury brings back their verdict. And if they bring back a guilty verdict, then there's a separate procedure you go through for sentencing. So if the defendant in a criminal trial is judged guilty, some punishment has to be decided. In most jurisdictions, it's the trial judge who will decide punishment, but occasionally the jury will be part of that decision-making process. In a 2004 decision, the US Supreme Court ruled that judges may not increase defendant sentences on the basis of what they perceive as aggravating factors, like circumstances that seem to make the crime worse. And in Blakely v. Washington in 2004, the judge reserved those determinations of this crime was particularly bad, so we need to add to the sentence for juries. So if you're going to be like, this murder was extra horrific, basically, so we should add more time, then that needs to be a jury decision. So in a handful of states, all of these decisions are made by juries. And especially in cases involving the death penalty, jurors rather than judges decide whether or not people will be placed on death row. And that was a Supreme Court case of Ring v. Arizona in 2002. That's a big decision, right? To send someone who, may have committed a crime, but is also another human being to death, right? So they want more than one voice in that process. And just like side note, which I think you all know, is if someone doesn't get the death penalty, it doesn't mean they go scot-free, right? They would often just end up sentenced for life. And sometimes, depending on the number of crimes they commit, they are given multiple life sentences. Okay, well, what if you are part of the court proceeding and you don't like how this turned out? Well, there's a whole process that you can go through in order to try to address this. So any defendant has the opportunity to appeal a verdict to a higher level of courts. And appeals are also possible in virtually every civil suit. So if you're found guilty and you don't think you are, or you think something was mishandled during the trial, you can appeal. If you are found liable, or if the person you think should be liable is found not liable, you can appeal. Now, the really interesting thing about an appeal is that we're not necessarily going to go through a whole nother trial in the same way. Instead, the appellate judges will read things like the record, the transcript from the trial proceedings. And this is why the presence of a court stenographer, that person who types frantically right in the front row, is so important, because we need to have a good transcript of those trial proceedings. The pleadings, which are the motions and accompanying documents filed by the attorneys. And then also briefs. The briefs are written arguments from both sides about the issues on appeal. So why is this being appealed? And then they decide whether to overturn the original decision or to let it stand. Appellate judges will rarely reverse a verdict on the basis of the facts of the case or the apparent legitimacy of the verdict. So even if you really think like, no, I'm not guilty, right? They're going to be like, look, people looked at all the evidence and they found you guilty. When they do reverse, it's usually because they believe the trial judge made some sort of procedural error. So maybe they allowed controversial evidence to be introduced that they shouldn't. Someone could appeal on the basis of they don't think an expert witness should have been allowed to be to testify, for example. Or their sexual history shouldn't have been included in their prosecution for rape, things along those lines. If the verdict in a criminal trial is overturned or reversed, the appeals court will either order a retrial, where basically they go through the process again, but make sure those procedural things are not violated, or they'll order the charges thrown out, in which case the person would be released from prison. And this is, I don't know how many people are podcast heads, but this is what's happening with the case followed in the first season of Serial, the podcast from NPR, Adnan Syed. So he, based on sort of evidence that they found and working with the Justice Initiative, he was released. His guilty verdict was overturned, but now they're sort of like retrying him. So it's, it's gonna go, this poor guy is gonna go back and forth for a while, it sounds like. In a civil case, an appellate court can let the decision stand, reverse it, in which case they would rule in favor of the side that lost, or they can make some other changes in the decision and remand or return the case to a lower court for reconsideration. Hey, you guys missed XYZ. Maybe you should think about that. Not maybe, they'd be like, think about that. You have to retry this. Okay, so really interestingly, I created these slides, I want to say in like 2011, 2012, somewhere in there. And in the past 10-ish years, some of this stuff has already come through, right? So the courtroom of the future, video conferencing. This is a thing now. They started it during COVID, and a lot of places are still using this. And so this permits live two-way video and audio communication. I mean, there are court cases being done on Zoom, right? I don't know if everybody remembers the I'm here live, I'm not a cat guy. If you don't, it was a lawyer who, when he signed onto his Zoom account, his child had been using this like goofy cat filter, where it's just the head of a cat and like only the eyes moved. And the guy was like, I'm sorry, Your Honor, I'm trying to take it off and I can't figure out how. I'm here live, I'm not a cat. And the judge is just like, I know you're not a cat. Right, but this has some real advantages. But also some really interesting things can happen with this. So for example, I remember watching a news story about a domestic violence case where they figured out that even though there was a restraining order, the partner that was the one being abused was in the same house, was basically being forced to be in the same house with their abuser. Their abuser was sort of almost keeping them hostage and like put them in another room and was like, don't mention blah, blah, blah. And they figured that out during the trial and like actually sent police over during the trial. So there's insights you can get in unexpected ways. It also just makes it more accessible for people, right? You don't have transportation, things along those lines. You can access it this way. One of our alums, Jessame Depor, works with child advocacy out in Arizona, and she's forever posting about like being in court on Zoom. And so they are still using this a lot for family court because that's a lot of moving pieces, a lot of people you're trying to get into one room, right? And it's a lot easier if you Zoom them in. Electronic and digital evidence. I mean, this is one of the things that came up in the Adnan Syed case, is that so he supposedly committed this murder at a certain time, but later on, I mean, they sort of didn't really understand how to use this technology during his initial trial. They were able to use cell phone tower triangulation to like see where his phone was at the time of the murder, and it wasn't there. It wasn't at the murder site. And so there's going to be more and more ways that digital evidence is brought in. People's Facebook, people's text messages, all of those are open for evidence now. I forget what the percentage was. It might have been like 50%. So the statistic I read a couple of years ago of people who were divorcing was like at least in part due to social media, that someone had like been emotionally cheating via social media or like connecting with someone to cheat with via social media. So that becomes an important part of digital evidence as well. We also now use computer animations and simulations. So, being able to, in some sort of traffic court dispute or particularly like a lawsuit, talking about injuries occurred as a result of a traffic accident, creating 3D model that showed this is what happened during the accident. And obviously technology, digital evidence coming in there with more and more traffic cams, right? Or over in the UK, they have closed circuit TV cameras everywhere. And so it's easy for them to pull video evidence for things. Obviously, there are other things we need to be careful about too. I don't know if people are familiar with deep fakes, but essentially what deep fakes are where you give an AI program hours and hours and hours of footage of someone, video footage of someone, And then you use that to create a video that looks like it's the person actually doing or saying something. Really, really scary, right? Because it looks real. And the AI technology is getting better and better and better. And part of, if anyone watches The Mandalorian, part of bringing back, I'm gonna not spoil it because people haven't watched it, but bringing back a character from the original trilogy and making them look like they were the age they were in the original trilogy involved doing a deep fake with that person. And using like a body double and then deep faking the face onto it. And so we need to be careful about stuff like that. We're also going to need to be careful about stuff like AI, right? So the whole ChatGPT thing and all the different things it can do, right? We need to start coming up with better tools. And then virtual environment technologies that allow observers to experience a recreation of the event as if they were actually present when it occurred. And again, some of these things, so I'm trying to think, oh, another good example, the guy who set his plane down in the Hudson, Captain Sullivan, something like that. Anyway, awesome guy, right? So he initially, like when they always have to have a hearing, like, did you do everything you could? And they kind of dramatized it for the movie. Like my understanding is no one was like, this guy screwed up. Everyone was actually like, wow, we're so impressed with what you did. But one of the things they did was like have people do simulations. And like, in theory, you could have made it to the airport. And he was like, wait, okay, so you have them immediately responding and doing that. Like you need time to process, you need time to actually like handle the controls. He's like, rerun the simulation, or did you rerun the simulation with that? And they were like, yeah, and every single time they crash. So like what he did was actually fantastic.
I actually just watched something on it. It was a 35-second delay they had to add to the simulation.
Yeah.
because they wouldn't take that beforehand.
Because it took time for them to process what was going on, and then like you have to wait for air traffic control, and air traffic control was like they didn't know what to do, right? And like if you listen to the original tape, you can hear the audio. If you just sort of search it, you can just hear the captain say, I'm gonna set it down in the Hudson. And they're like, you're gonna do what? Excuse me? And then by that time, he's like down and doesn't have power. So like, you know, it was really just way too late. What happened in that case, if you're not familiar, is that both engines got taken out by bird strikes. So like that just means each engine sucked in at least one piece and just that just destroyed the engine. So we're not the only ones with geese problems. I don't know if you've ever heard President Miller rant about the geese. It's kind of funny. Alrighty, so we've mentioned previously some of the ways that we look at things alternatively, right? We talked about like drug courts and things along those lines, but there are also just other ways to decide things, and these are called alternative dispute resolutions, or ADR. And most cases are actually resolved via ADR in this day and age. Again, as we mentioned previously, very small percentages of cases actually make it to trial. In 2009, only 1.2% of federal civil cases were decided in a trial. And in 2002, only 4.7% of criminal cases involved a trial. So that means the vast majority, 95% plus, of trials are being handled via negotiation, plea deals, things along those lines. So a lot of cases are just settled by negotiation without any assistance from a third party other than attorneys, right? And negotiation may be formal. So for example, in civil cases, there might be management and union representatives that are negotiating either a contract or a case involving some sort of personal injury, but they can also be informal. So for example, some people who just realize like, we're not in love, we don't want to be married anymore, are able to work out their custody agreements and the details through what's called collaborative divorce. And they don't need to go for trial, and they don't need a mediator, right? They just sort of figure it out. Arbitration is one form of ADR, alternative dispute resolution. When the parties agree to what's called binding arbitration, they agree to accept the decision of the arbitrator. There we go. So in this case, it would be like that person is going to make a decision. Everyone is going to agree to whatever that decision is. You can also have non-binding arbitration, which is where if one of the parties is dissatisfied with the arbitrator's decision, that person may ask to take it to trial. Arbitration, whether binding or non-binding, does use trial-like procedures. The parties present evidence and argue the case, and then the arbitrator is going to make that decision. However, in recent years, arbitration itself has been criticized as being overly formal and overly time-consuming. So again, a lot more people are trying to just kind of like work stuff out themselves, particularly in these like divorce and family cases. You can also have what's called a summary jury trial, and this is like a jury trial, regular conventional jury trial, but shorter. Lawyers tell jurors what the witnesses would have said if they were present. The lawyers argue the case and try to answer jurors' questions about the facts. The judge tells the jury what the law is and also tries to answer jurors' questions about the law. The jurors then go deliberate and come back with their decision. So it's like only the lawyers and the judge and the jury. You're not bringing in lots of witnesses. In recent years, verdicts from summary jury trials have become binding and enforceable. The process educates lawyers and clients on how a conventional jury might view the facts and the law. And once educated, lawyers and clients are often more amenable to settling the case. Mediation is another form of ADR where you use a neutral person, who's called the mediator, to work with the litigants and their lawyers to achieve a settlement. The mediator doesn't have the authority to decide the controversy, so they're not like the arbitrator. They can't be like, this is my decision, but instead they act as a facilitator. They meet with each party in an effort to broker an agreement. So they're just sort of like a go-between. People often prefer mediation because they're risk averse. Because if you take something to trial, right, the judge and or the jury are going to make the decision and that's it. Whereas if you work with a mediator, it's being settled by you and the other party, right? You have more of a say in theory in what's going to happen. Compared to divorces that go to trial, litigated divorces, research suggests that mediation encourages parents to comply with divorce agreements, remain involved in their child's lives, and renegotiate relationships in a more adaptive way. And that's probably because they have more buy-in, right? They are part of the process, and so they are more on board with the decision. And so what are beliefs? What do people think about ADR? So participants tend to favor options that offer them more control. So something like a mediator, a neutral third party, helping them arrive at their own resolutions and processes that allow them to control their own presentation of evidence. And so other people have asked, well, if this works so well, why don't we just force settle courts, like force people to just go through mediation or other forms of ADR? Attorneys like the process. They believe it's fair and it saves client time and money. However, if you mandate, if you say you have to go through ADR, it can lead to an unintended effect, where you feel less invested because you've been ordered to go through this process. And also some lawyers will file meritless claims, knowing that these claims will have settlement value, or they'll get more money in mediation. Whereas were you at court, the judge or jury could easily be like, no, right? Just toss it out. All right, so what are some of these community alternatives? So we again mentioned the problem-solving courts previously. And those were developed to rehabilitate and monitor individuals in the community rather than just throwing them into prison, right? Rather than just incarcerating them. And so these alternatives that we're going to talk about pertain to criminal law, criminal cases only. And so some of the justifications here as to why we should use these, and yeah, I don't have this on the slide, so I'll just try to speak slowly. The first one is humanitarian. That you're less likely to get cruel and unusual punishments through these processes. The second is the cost. It is much less expensive to monitor and treat an offender in the community than it is to incarcerate them. And the third is access to the care they need. So correctional facilities house inmates who, as a group, have wide-ranging rehabilitation needs. When populations are more homogeneous, like in a mental health or drug treatment setting, and security concerns are fewer, then you get better treatment, more specialized treatment, and even more intensive treatment. And so the sequential intercept model identifies 5 stages of the criminal justice process at which you can interrupt the standard steps and do one of these alternatives instead, do a community treatment alternative. So it says, you know, at any of these stages, we can just stop trying to like punish this person and instead try to help them. So the first is that law enforcement and emergency services. So when we talked about police, we talked about like crisis intervention training and having a crisis intervention team, right? If there are people who are educated, a lot of people, activists right now are advocating for like rapid response social workers to deal with mental health situations, right? If any of those come into play, when you have someone with a mental health issue that the cops are called on, they're going to get much better treatment. They're going to be, again, perhaps instead of taking them to the police station, they would take them to a hospital, right? And voluntarily hospitalize them rather than have them sit in a jail cell, that type of thing. Yeah. Yeah, and that's something where these trainings can come into play as well, right? So like, if you don't have any mental health training as a law enforcement officer, you may try to treat someone with a mental health issue as if they are just as with it as someone who doesn't have a mental health issue. And unfortunately, there are cases where, and we know, I'm fully acknowledging, there are cases where someone does not have a mental health issue and they are killed by the police unnecessarily, right? But where someone is not complying simply because they have a mental health issue and they don't understand what the cop is asking them to do, and thus are, you know, injured or killed as a result. So yes, having this training helps people realize in the moment, oh, this person doesn't understand what I'm asking them, right? And try to intervene in that way. Also things like just the type of restraints you use. So we had this like horrific grand rounds when I was in graduate school, where they showed us videos of, you know, like people who are having acute mental health crises, and how like even like a normal police force can have much more profound physical effects on them because they've already got their adrenaline racing and things like that. So just knowing like you don't want to kneel on a person's back, you shouldn't do that anyway, but like you don't want to like restrain their arms in certain ways because it can have much worse conditions because of sort of all of the neurotransmitters, hormones, all that stuff already flowing through their bodies. But yeah, so this is why this type of training is so important. You can also intervene post-arrest. So during the initial detention or initial hearing in the pretrial services, you might realize, oh, this person is having some mental health issues, right? And so the lawyer, the prison guard, the judge themselves can start to make suggestions for intervention then. Post the initial hearings, you can also intervene here as well. So while they're in jail or prison, the courts can, this is where we would start to court order things like, are they competent to stand trial? Let's do an evaluation. Is this someone who is gonna need additional services while they wait for their trial? And this is also where those civil commitments might come into play, right? Where, okay, what's really going on with this person is a mental health issue that they need intensive care for right now. And we can't just like release some of the folks because their mental health issues are so severe, they've lost touch with reality and they're a danger to themselves and or others. Re-entry from jails, prisons, and forensic hospitalizations. So this is a big issue that a lot of psychologists are doing a lot of work on, is like when people get out of prison, it's like a whole new world, right? So even if you're in there just a couple months, it can be difficult. But let's say you were imprisoned in 1993 and you served 20 years, so you're getting out this year. The world you're coming out into is completely different, right? 1993, people didn't have cell phones. I think at that point, the only like mobile phones you had were literally like, they looked like a suitcase, you had to plug them into the car to use them, right? Technology in general has advanced, right? The political climate is so vastly different, right? And so even if you don't have mental health issues to begin with, some people struggle with that. And so a lot of places are really trying to work with people on reentry, provide support groups or therapy to help them adapt. We do a lot of this as well when we can for armed forces members who come back from war. One of the like most poignant scenes in a war movie for me ever is the movie The Hurt Locker. At the end, Jeremy Renner's character, like they've shown throughout the movie that they're like, eating the MREs and they're like in the field and watching people die and all these terrible things. And he's just like standing in the cereal aisle of the grocery store with all these choices and completely overwhelmed. Right. And I thought that was just such a nice portrayal of how overwhelming the abundance we have is, right? It's sort of like the first world problems that we have. And then also community corrections and support. So, what other support do we have in place? Are we throwing this person on the street to be homeless, right? Or are they going to be followed by a parole officer? Do they, have some initiative? Do they have somewhere to live? Alrighty, so we've mentioned these problem-solving courts before, but I'll just sort of mention them again in passing. The idea here is therapeutic jurisprudence, which is just a fancy term for using the law to improve people's lives rather than punish them. And so the legal system should help troubled individuals cope with the problems rather than just punishing them for some things that they sometimes can't control. So for example, with drug courts, you're going to link drug addicted offenders with treatment programs and extensive supervision. In exchange for successful completion, often the original charge is dismissed. And the findings here are encouraging that this does seem to help with decreasing not only recidivism, but also relapse. Mental health courts will basically address folks recognizing that oftentimes we think, and we see this unfortunately with like school shootings, right? The knee-jerk reaction is always like, well, that person had mental health issues and that's why they did it. Other countries have people with mental health issues and don't have as many mass shootings, right? Like there's something going on in America culturally that we need to address. But the idea is, in fact, a lot of times the criminality might be caused by necessity because of their mental health issues. So again, going back in time to the 70s, there used to be these state hospitals. They were not great, to be perfectly honest. The conditions were not fantastic, but people had a place to live for the rest of their life if they had severe mental illness. And during deinstitutionalization in the 70s, they just closed them. And they said, oh, go out into community-based mental health facilities. And so that's when homelessness skyrocketed among those with mental health issues. A lot of times the folks don't have the wherewithal to know how to get a job, right? How to hold down a job, things along those lines. And so not only are they experiencing higher rates of homelessness and unemployment, but oftentimes they're turning to drugs and alcohol to cope. And they are often the victims of abuse by others. They're taken advantage of, physically abused, sexually abused. They also experience high rates of incarceration, but most, particularly local jails where you might be held, a shorter term sentences or while waiting trial, most of them do not have good treatment resources. So there's this hypothesis called the criminalization hypothesis. There's a subset of mentally ill offenders who are committed, who were arrested for offenses caused by the untreated symptoms of their mental illness. So, and this can be sort of like down the run, right? So, okay, this person can't get a job and hold it down because of their mental illness. So they don't have money, they're homeless. And so their crime is they stole something, right? To try to eat. It's like you can see the cascade from that, right? And so mental health courts were developed to try to decriminalize this population. If the offender is diverted into mental health courts, the mental health team prepares a treatment plan to lead to long-term psychiatric care and reintegration into society. Close monitoring is an essential piece of this, and the charges are dismissed if the offender is able to follow that treatment plan. These tend to be moderately effective in linking individuals to treatment services and in reducing recidivism, as long as they complete the full treatment plan. They call it sort of a full dose. There are two common concerns. One is that in order to get their charges dismissed, people may feel like coerced into getting help. And one of the things we know from just psychology in general is like the person has to want to change. You can't want it more than they do. So it may not be as effective for that reason. And the second concern involves the selection of participants. And then it may be the selection process rather than the interventions that account for the positive outcome. So what are we doing in terms of socioeconomic status, right? Are we making sure people who are poor are getting in as often as people who are richer, right? Are we making sure we have gender and racial equity and who's getting these opportunities? Homelessness courts are designed to reach out to these marginalized individuals to address the underlying problems that resulted in their homelessness and then reintegrate these people into society. Typically, they go through shelters or other agencies that serve this population. Domestic violence courts in recent years have coordinated efforts to hold perpetrators accountable, enhance victim and child safety, and promote informed judicial decision-making. These courts start from the premise that the offender's behavior is learned rather than rooted in a treatable addiction or illness. So the court proceedings are less therapeutic here. But both victims and perpetrators express satisfaction with these types of proceedings and their outcomes. And perpetrators are much more likely to comply with judge-ordered conditions here, such as restraining orders. Community courts are neighborhood-focused courts that are designed to address local problems, things like vandalism, prostitution, shoplifting, vagrancy. And participants generally, and I guess genuinely, like how they're treated in these courts. So often there are alternative sanctions instead of, again, being imprisoned. And then veterans courts. In a typical veterans court, a district attorney may opt to defer prosecution or offer a plea bargain to a reduced charge if it's clear the offense was related to the veteran's disability. And here the disability is often mental health related. So for example, something like PTSD. And the veteran agrees to seek treatment. Offenders who are diverted to a veterans court are less likely to reoffend than those who go through the traditional system. Now, there are some criticisms of the problem-solving courts. One is that the demographics of judges just don't match up with the people who go through these courts, right? These are often going to be middle class, white, cisgender, right, straight individuals who probably haven't had a severe mental illness. You most of the time have not experienced homelessness, right? And so there's the idea that people may be, the judges may act in like an inappropriately paternalistic way in what they require of people. They kind of treat them like children. And some have argued that problem-solving courts lack legitimacy because threatening punishment to coerce rehabilitation is unfair, and because guilt or innocence is not determined by a trial, right? You're going through this process instead. Prosecutors also sometimes feel pressured to favor these types of courts, to favor rehabilitation of the offender over protection of society. And defenders can feel pressured to plead their clients guilty and to inform the court of their client's failure to comply with these things, which then can get them moved over to a traditional court system. Researchers who study these types of courts worry about the lack of rigorous empirical studies that assess how these courts influence or perhaps fail to influence offenders' future conduct. Alrighty, so we got done a little early, we got all the way through, and on Thursday, we're gonna start talking about jury selection and how psychologists are involved in that. So, thanks to those who were able to come, both in person and on Zoom today. Just gonna make sure I didn't miss anybody. I think I'm good. Bye, everybody. See you on Thursday.